Well, in a landmark ruling last Friday, the Constitutional Court ruled against the exclusion of adopted children as beneficiaries under a trust. Up until then, legislation excluded adopted children from an inheritance unless the deed conveyed a clear intention to include them. Well, Judge Nonkosi Mhlantla ruled that exclusion of adopted children based on their birth only served to perpetuate discrimination against them. Mhlantla also stated that family life, as contemplated by the Constitution, can be provided in different ways, and that legal concepts of the family and what constitutes family life should change as social practices and traditions change. Well, let's unpack the implications of this. What does it all mean? We chat to Cliff Decker-Hofmeyr, Executive Consultant for Trust and Estates, Johanna Jacobs. Johanna, very good morning. Thanks so much for your time this morning. So quite a mouthful that, but a very fascinating case that this emanated from. Explain what this ruling actually means now and who it's important for.
Yes, good morning. Indeed, it's a landmark decision. Also, to put it into context, in the early 2000s, a number of cases came out from the various high courts and the Constitutional Court challenging discriminatory provisions in so-called public trusts. The first one was the Minister of Education versus Seifert, where a public trust was created, charitable intent, but certain categories of persons or individuals or groups were excluded based on either race or gender or religious affiliation. And the courts came out unequivocally stating that our law is imbued with the Constitution and the Bill of Rights, and where a trust in the public domain discriminates against groups, that is to be excised and treated as pro non-scripta, in other words, as if it didn't exist. The literature then over the years developed saying, would this ever be extended into the private realm? In other words, where a person creates a private trust for his or her family or a group, or even in their own particular will. And the debate was always most probably not, because it's in the private realm and autonomy and testimony freedom was sacrosanct. The current matter must also be seen in conjunction with a decision that came out of 6 weeks earlier, namely the King decision, which affected a similar discriminatory provision in a will as opposed to a private. And in essence, what the Constitutional Court stated in its majority judgment, it's highly complex. You know, the judgment runs into 191 pages, three judgments, two minority decisions, was that despite the interpretation, because what the court looked at, it looked at the trustee, looked at the interpretation, looking at the words, you know, the words were child, children, descendants, legal descendants, where the tension lay, plus the Children's Acts that were at that particular time, and said that the adopted children could not be treated or could not be brought into the fold based on pure grounds of interpretation. And that was essentially unfair. In other words, it discriminated against a group and therefore should be excised. So that's the judgment.
What does this actually mean now going forward? What does this ruling mean for if I were to drop if I were to drop my private will? Does it mean that if, for example, I want to state there that so-and-so is adopted and shouldn't get whatever it is from my estate, would that now be illegal? Or would that, how does it work for anybody going forward who wants to draw up their will? Can you do it? Can you not do it? What conditions would they have to be? Or as nasty as that may, I mean, I can't imagine anybody who would want to do that, but just for advice going forward,
Yeah, sometimes people use a will as a last opportunity to have the last word or to be vicious. But yes, so look, if you think about a will, in essence, it's about differentiating. You include your family, you exclude strangers. You include a favorite niece, and you exclude a recalcitrant nephew. But what the court judgment implies that you cannot exclude somebody based on group characteristics, immutable characteristics. So you can say exclude somebody because you don't like them, or because they didn't visit you, or because they're wealthy enough, but you can't based on a characteristic that's immutable, for instance, being adopted or being born out of wedlock or belonging to a certain religious group, because that would be an anathema to the Constitution. So yes, in drafting wills, testators and their drafters will have to take heed of this. But I think it's more a constitutional victory. I think in practice, in private law, people do not tend to discriminate on characteristics. They discriminate on idiosyncratic characteristics. You know, they like somebody, they don't like somebody, and that you still are allowed to do.
All right, so not based on the circumstances of someone's birth or how they came to be in the family. Thanks very much. Unfortunately, that's all we have time for. Jan Jacobs, Executive Consultant for Trusts and Estates at Cliff Decker Hofmeyr. Well, Gazina fire survivors say life is difficult in the tents they're living in. It's been 7 days since the Carson building not far from Kwaimai went up in flames, killing 9 people. Now, those left destitute are worried about the conditions they are living under. ENC's Ngobile Matlala spoke to the survivors.